Good afternoon, everybody, and welcome to our latest podcast on all things related to business immigration to America. Today, we're going to talk about probably one of our more popular programs, which is EB-5. And this episode, I'm really excited to talk about it with my colleague as well, that we're going to talk about everything you really need to know about making a decision about going forward with an EB-5 investment and an EB-5 application. This podcast is definitely for people such as yourselves, investors, families maybe that have been living here for a long time in some other status that might be ending, possibly high net worth individuals or investors who are looking at long-term U.S. residency, ultimately acquiring citizenship if they like, and something that could help solve this issue for their entire family. So today with me, as often when we're talking about EB-5, is my colleague, esteemed colleague and senior associate, Yulia Novik, who heads up our EB-5 department. Yulia, thanks for joining us today.
Good afternoon, Charles. Good afternoon, everybody.
So we can kind of dive into this. And I think this is this is going to be a podcast that's a little bit more of a condensed, intensive overview. If you're interested in kind of getting the longer version, we have an EB-5 course that we'll have a link in the description below the podcast where you can get a more in-depth course where I think it goes for 2 or 3 hours, where we do a deep dive into all things related to EB-5, the process, all that other stuff. But if you don't have time for that, we thought we would do a bit of a shortened podcast, within 30, 40 minutes in a briefer format that will give you an overview of what the EB-5 program really entails. What are its pros and cons and difficulties that we encounter? How is this compared to, say, the proposed gold card that President Trump and the White House has been proposing, and basically get you in a position where you're prepared psychologically and maybe financially to make a decision about whether you should go forward with the EB-5 process. Now, the one thing I want to mention, and Yulia will jump in here too as well, in a moment to help go over this, is why this is also relevant right now is because the grandfather clause is scheduled to end on September 30th, 2026. So what does that mean exactly? It doesn't mean the program's ending. It just means that as the current terms currently exist, in terms of the dollar amount, the adjudicatory standards, the requirements, as everything stands right now, as long as you file by September 30th, before October 1st, then you will not be affected by any subsequent changes to the program. So we've already noticed this recently, and we're sure it's going to continue to increase. We've noticed an uptick in interest among people who have been sitting on the fence maybe for a long time, not sure about whether they want to go forward with EB-5. And I think they're kind of realizing if they're going to take the plunge, now is the time to do it, because after September 30th, nobody has a crystal ball. I'm not saying everything's going to fall apart. The dollar amount's going to increase to $1 million and stuff like that. But any changes that do occur after September 30th, if you file, you would be subject to those changes. And I guess these are just big unknowns, and the unknown unknowns are often scarier than the known unknowns, right? And at this point, Congress, the White House, nobody's made any kind of indications as to how they might change things after September 30th. So what we're recommending to a lot of our clients is, if you're looking at EB-5, now is maybe the best time to do it. And when I say now, I don't literally mean now, in spring of 2026, maybe late March. But I would say, and Yulia and I will discuss this a little bit later, if you take into account the time that's required to prepare a case, select the project, get the money lined up, make the investment, you can't come to us in September of this year or even August and realistically expect you can get a case put together. I mean, cases on average take 2 to 3 months in a best case scenario. Oftentimes it can take longer. So if you're looking to meet that October 1st deadline, we're coming up close on the deadline when you need to make a decision about going forward in order that there's enough time to get everything done and get it done correctly. So in terms of background, I presume everybody knows basically what the EB-5 entails, right? You're making an investment of about $800,000. I shouldn't say about, at least $800,000. You could also make an investment of $1,050,000, but very few people do that, just because the vast majority of projects are in the $800,000 range. And in order to qualify at the $800,000 level, you have to invest in either a rural project or an urban project that's in what's called a targeted employment area, meaning it has higher unemployment than the national average. So the vast majority, 99% of clients are investing in projects where they qualify for the $800,000 level. And again, the vast majority of clients are entering the program through the regional center project. You could also open your own business, do what's called a direct EB-5, but we have less than 5% of our clients do it like that, and I think that's true industry-wide. That very few people file for an EB-5 based on their own business, just because it is a lot of work, a lot more work than working through a regional center. Now, here's one thing, and I wanted to pass over, start our dialogue with Yulia in terms of what's required. But here's what I would say is kind of a typical investor profile for people looking at EB-5. And Yulia, you can add your thoughts to this too. I think the biggest concern for EB-5 investors is, losing the money and not getting the green card. And I should say, in terms of priority, it's probably the opposite. Their biggest concern is not getting the green card. And then second biggest concern is not getting their money back. And those are very both important considerations. And as a result of that, investors tend to choose safety over, high returns, because investors are not doing this to get rich, and they're not doing this to make a lot of money, or even to make much money, if at all, right? They're doing this in order to secure their family's future in the U.S., get a green card on a relatively predictable timetable, and theoretically, and this is almost always how it works out, get their money back after some period of time when the investment cycle has completed. I know you deal a lot with our investors directly as well, Yulia. I mean, would you agree with that assessment, or are there other considerations?
I mean, at the beginning, of course, clients are asking whether they will be able to return their money and when they will be able to return money, because they think it's connected to the same immigration process that we are working on, when in reality it's a separate contract with the regional center. And even if there is a law allowing to keep money for a specific amount of time, if certain conditions are fulfilled, still regional centers may keep them longer. So yes, I would say that many clients do ask at the beginning, but then they realize that it's more about green card rather than returning money. It's more investment in green cards and return on investment.
Right, exactly. And so that's interesting. Sometimes we see various projects where they might offer a higher return. The average in the industry right now is maybe 0.51% per annum, which is extremely low, right? It's below the inflation rate, basically. And there are projects out there that sometimes they offer 2 to 3%. I've even seen a current project on the market with a very reliable developer that's offering 5 or 6%. And it's interesting that that income level tends not to attract investors. They might either be suspicious, why are they offering 5% when other people are offering 1%? And I have to tell you, we're not talking about any particular projects right now, but in general, just because a project is offering 5%, that doesn't necessarily mean it's a riskier project. In often cases, it is not risky. It just means that the developer or the regional center is more willing to share the returns with the investors, as opposed to these other projects that are only offering 1%. Because believe me, when they offer 1%, there's more margin in there that they could be offering to investors. It's just they're choosing not to do that. But you're right, Yulia, absolutely. That this is, people are they're looking at predictability over profits. I guess that's maybe the best way to put it. I think, again, as I mentioned, probably the ideal candidates, at least at this point in the process of the EB-5 cycle, given the current rules, given the ending of the grandfathering clause, et cetera, I think that the ideal candidates, or the most common candidates that we see for EB-5, are families that maybe have already relocated to the U.S., maybe on an E-2, maybe on an H-1B, maybe they have a pending I-140, but that's been retrogressed and they've been waiting 5 years, 10 years, et cetera, for their place in line, and they're kind of giving up, waiting. And they've settled in the U.S. They have roots here, or they're planning to be here long term, and they're just looking at the EB-5 as the most reliable option and predictable, maybe, to acquire permanent residency here in the US. If this is somebody looking to make a lot of money, this is not your program, right? And if this is somebody who's willing to take on a lot of risk, or maybe this is somebody who's looking to launch their own business in the US, you could use EB-5 to launch your own business, but given the restrictions and the requirements, sometimes it's better to start with a non-immigrant option, such as an L1 or E2, and then maybe convert that over to a green card, not necessarily through EB-5, maybe through EB-1C, maybe through some other options, but it really depends on the circumstances. But let's get back now to kind of our overview of the EB-5. And so, Yulia, my first question to you, and this is something that you have a tremendous amount of experience, 10 plus years working on, is the number one challenge for EB-5 clients, right? Source of funds and actually tracing the funds as well. Why, maybe you can give a little taste of why this part of the process is difficult and why it usually takes more time than clients imagine.
I would say it's difficult because most clients do not understand and they come to us thinking it's something easier. And many of our clients, they have foreign accounts and they say that each bank checked me, I showed my tax returns and that's enough. So basically, it's not the same that you file tax return and that's it. It depends which business you're involved to.
And here, and on top of that, like business. So let's say, for example, and this is common, as you know, we have a lot of business owners that are filing for the EB-5. And they might say, hey, I've had my business for 20, 30 years. Look, I'm clean. I'm not a drug dealer. I've had, my insurance business here I developed, or a consulting business, or a small manufacturing business in my home country. I can show you, I've been doing this for 25, 30 years. Everything's above board. And the funny thing is, I don't think they realize that is not actually an ideal situation, because from an EB-5 perspective, if you've got a business that's been around 25 years, that can actually create more complications. Can you provide a little insights why that would be complicated in that kind of scenario?
Of course, because we don't trace money just from your business. We don't take dividends and tax returns and bank statements and that's it. We have to look into type of business. We have to see if you invested any funds into opening your company, invested assets, invested money, because most of the companies, they are not involved in services. They're involved in some kind of sale or building, construction, and those types of activities, they require money to start with. Yes, they require capital to start with. And when you started business many years ago, most likely you will not get those documents. And I understand, like clients explain to me, we didn't have a need to keep them. Statute doesn't require us to keep those documents for so long. I understand as a human, I understand it all, but the officer wouldn't understand it. We have to
because you're kind of saying they're not humans, immigration officers?
I mean, as a human, I understand.
Right.
As a lawyer, I'm sorry, but you're out of luck. We do have to go 20, 25, 30 years ago, doesn't matter how long, and show how you started your business. If you received your business from your parents, from someone else, we have to show you inherited it or they gifted you. We have to show how they established that business, because gift by itself is not a source. It's an immediate maybe source if you invest in funds that are gifted right now, but it's not a source per se. We have to go back, see the person who gifted you money, show their reputation, show how they earned that money and how they earned money to invest in that business or whatever else they gifted to you.
Right. So like if you're looking at things that realistically or on a practical level, right? And I know this from our work and you're working with clients and et cetera, if they opened that business 25 years ago, we've got to provide bank statements kind of from 25 years ago. We have to provide possibly wage statements. Let's say, our client opened his business 25 years ago. Before that, he was working just as an employee somewhere, saved up some money, and he put that money into his own business and started, growing that business. We've got to show, those wages that he, saved up at the previous job, and then showing that, he put that money into his new business, his startup business, and that was adequate to get things going. And, 25 years later, here we are at the EB-5 stage. And so I think
what I wanted to add, show meaning not just pay stubs or that you were earning specific salary shows a path how it was deposited, accumulated, saved, and then transferred to your own business. We cannot have breaks in continuity of the path.
Yeah. And that's something USAS has really been focusing on over the last year or so. That, as Yulia said, showing that continuity of path of funds. Like they literally want to see, okay, the money was in your savings account and then you put it into your newly formed LLC that you opened 25 years ago. And then, that money was then used to develop it. And so I almost think, Yulia, it's probably fair to say maybe some of the biggest challenges with EB-5 lately in terms of how the officers are reviewing stuff, probably the bigger challenges are more with the path of funds as opposed to the source of funds. I mean, it depends on the case, right? But
I would say in every case, source of funds, it's if you're involved in illegal activity or, as we know right now, sanctioned business. That's the basic challenges. Otherwise, if it's salary, dividends, we can put together a picture what you're doing, but the path is the most complicated part.
Right. Yep. I agree. And so that's why, and this gets back to then our earlier question or comment that I had, is sometimes people come to us and say, hey, I've been in the US for 10 years, W-2 income for the last 10 years, straightforward. We want to sign tomorrow with you guys and we want to file by the end of the month. And I don't think they don't realize that just providing your tax returns for the last 10 years, is going to be adequate. And even if you have a relatively straightforward situation, like say W-2 employment in the US for the last 10 years, theoretically, employment income is one of the easier sources of funds to prove, but there can be complications when we come to the path of funds, right?
Rarely people keep their funds on the same account and without interest. People invest. And Charles, this is the most common situation right now is people living here in some non-immigrant status, lawfully and working. It looks easy because it's America. We get documents from here. We get W-2s. But it takes a lot of time to put the path of funds together because people transfer them from account to account. Then we figure out that account has some, for example, rental income. Why? Because we purchased a property. And then we go back and we see how we purchase the property, whether we use a mortgage, how we paid off the mortgage. So it's not impossible, it's doable, but it requires a lot of effort. And right now with modern Zelle, it's probably something that gives us most trouble. Everybody sends money to everybody. People don't even remember who they borrow to. It's Zelle, you press the button, you send money, and then people are sending you back. And when we see money coming from Zelle, from a known person, that's a problem. Those are commingled funds. So yeah, salary is never, it should be easy, but it's never easy.
Well, and you bring up a very important challenge with a lot of our clients. And surprisingly, this comes up maybe even more with clients who are living in the US or maybe Canada, which is a very similar system to the US in terms of taxation and other stuff, is this issue of commingled funds. And so for our viewers, I'll explain a little what Yulia was referring to. So commingled funds refers to that situation where you might have one bank account, and let's say that's the account where you received all your dividends from your business or all your salary, right, from your W-2 job. And we can show that, hey, you saved up $800,000 there. Or we can show you cumulatively received those funds, but maybe you put them into a Robinhood account or another brokerage account to make some investments, but you could always move it back to the checking account. That's all fine and good. There's no problem there. But the issue of commingled funds comes up, like Yulia said. Maybe you lent some money, maybe before you moved to the US, you lent some money to your brother, $20,000, 10 years ago. Now he pays you the money back. He pays you via Zelle or just a money wire or something. And that money comes back into the same account that you're receiving your salary. Now, all of a sudden, the government's going to be, well, wait a second. We see income not just from your job or from your dividends. We see this installment or payment of $20,000. What's this about? You're going to have to prove where that came from. And depending on the circumstances, it could be a challenge, proving where that came from. So that could be an issue. Even, gifts from family members. Clients tend to think, well, hey, my dad gave me $500,000 or something. He's retired, but he's totally clean. If you're getting a gift, right, Yulia? I mean, we have to go through the same analysis as if that person were the investor.
Yes, it's like I was saying that gift per se is not a source of funds. Gift is just like we're transferring our attention to another person. Basically, we will have to collect your documents, your personal documents, your tax returns for 7 years, judgments against you still, and like personal documents. But then we go to the person who gave you the gift.
Right.
And we go through the whole life of that person, basically, because we have to look at the tax returns too. So basically, maybe he earned salary. Maybe he was finishing the job. It was bonus. But then he put it on some account where it commingled with his older funds. Also, what is the problem with this type of situations? We ask those people who gave the gift to provide their tax returns for the last 7 years. And why we ask? Because USCIS started to ask it independently from the source of funds. Any company you had ownership interest in, your sole proprietorship, your personal tax returns, we have to provide them for 7 years, because otherwise we're going to be asked for.
Right. Absolutely. Yeah. And that's the requirement. 7 years of tax returns. That's a requirement no matter what. So now hopefully, so again, the point of all this is not to scare people, but it's just to maybe pull back the curtain a little bit so that people can understand what's all this stuff going on in the back room there. What are these lawyers working on? Why does it take 2, 3, 4 months to prepare a case? And I think hopefully our viewers understand now this is what's required if you're going to do it right. Now there may be, time, constraints. There's a deadline. Your son is turning 21 in 2 weeks. Sure, we could send in what's called a bare petition. That's, just has the very basic information just to get it filed in time. And then you provide the other substantiating evidence later. Although that's becoming more of a risky proposition as well, right? Because we're seeing Yulia, it was unusual. We had a client, for example, he even provided all the documents, right? We had a very good case, and they issued an immediate denial. They didn't even issue an RFE. I think we were all shocked by that situation.
Which is very rare, and which is actually they're not supposed to do unless the petition is so
unapprovable, inherently unapprovable.
Unapprovable, yes.
Right.
So there is no way you can provide them any document they would ask you for. But in our case, the questions were actually laughable. They really made me smile, although it was a denial. Seriously, where you kept 20 kilograms of cash, you didn't provide us evidence.
Yeah. They even went so far as to make a comment that the client said he stored a lot of his money in cash, which anybody from a developing country knows the banks aren't always too reliable. And it's not surprising for anybody coming from a developing country to say, hey, we would store a lot of money in cash just because it's safer, literally, than putting it in the bank. And the officer was challenging that proposition, like, where could you hide or place 20 kilos of cash? How he even knew what the weight would be of that, cash? I don't know. Maybe they did some calculations with the help of AI or something, but yeah, it was comical what they were saying. So
basically, why we're saying it, Charles, like you mentioned, that we don't want to scare you. No, it's mostly motivational speech, I would say, for you to start early, because it's not that we don't want to file you. If you come in September, we won't be able to, because as Charles said, petitions that lack most of the documents, like we used to file maybe in 2019, that we are still answering to responses, not even all of them were approved. At that time, USCIS was kinder to petitions. What's going on right now? Partial funding. Thanks God we didn't have even one client with denial, but we've heard from regional centers that if you did not say exactly which funds, did not show the source of funds with the first petition, you're going to be denied. And we've heard about many of them.
Right.
So come earlier, because when you think it's just a salary, because what else I was doing, it may be just a salary, but your salary may be in some bonds, in some other accounts. Your salary may include even rental payments. Why I'm mentioning it, because it's something that I'm dealing with right now, 6-7 years, and it was just a salary. And then we go, wow, where those money are coming from? Rental. Okay, when did you buy it? Which money did you use? Yeah, you use salary. But it takes a lot of time to collect those documents. And even if you are able to collect, we have to go through each transaction, whether it's 100 pages, whether it's 1,000 pages, because right now we're dealing with a petition with 1,000 pages, and we know those are not all pages. We already know that there were other sources we don't have bank accounts from. So come early. It's not in our interest. We want to file your petition, but we want to do your best so it is approvable, and it takes time.
Right. The other thing too, I might add in terms of the source of funds, what we're talking about, the simpler the better, right? You don't want to overly complicate your story, your petition. And what I mean is, when it's possible, we try to minimize the number of sources of funds we're using. Not only does that make our job a little bit easier, maybe as attorneys, right? But it also makes the whole petition a little bit easier to understand, because if you've got 5 different sources of funds that you're using to accumulate that 800,000, it gets wearisome for the officer, right? I mean, they're gonna get confused, and if they get confused, you're raising the likelihood of getting an RFE or even a denial, because if they can't clearly kind of understand where things are going, and there's too many sources and too many paths and money moving here and there, just keep it simple. That's also some advice, and that's certainly something we always work with our clients on, because our clients might say, hey, look, I got these 3 sources of income, let's use these 3. But if we can look at them and say, hey, let's forget about this third one, if we can use, say, just 2 of them in order to achieve our same results in 99% of the time, right, we'll do that instead, because that's something also to keep in mind.
Basically, I would say that sometimes clients don't know what is there on their account. They say it's just a salary and there are other funds. So we are the ones saying, no, there are other funds. And they say, oh yes, but this is minor. No, it's not minor. We have to explain it. It takes time. But then we discuss it with client. We ask questions. We sometimes work with their financial advisors or accountants, and we figure it out. But then even for us, I can draw a table for myself what it is to remember, but we do not communicate with the officers. We give them a paper and they have to read it and understand and know which paper, which exhibit to connect this paragraph to. This is hard. This takes million time, Charles, because sometimes I'm telling you, I have all the documents. I understand. I just don't know how to write it so it's clear. Yeah, and it takes time.
Yep,
yeah,
absolutely. Like that. Yep. So hopefully that kind of gives a little clarity on the work that's involved and why it takes as long as it takes. I'd like to go over a step-by-step overview real quickly of the entire process so everybody's clear on that. So this is kind of a typical process that we follow with our EB-5 clients. Usually starts out with an initial consultation. We'll talk to the client initially about the requirements in general. And then if they're still serious and interested in going forward, we'll have a more detailed call, usually with Yulia, to go over their particular sources of funds so that at least verbally we can get a good understanding of what those sources are. And if we feel pretty confident that we can put together a good petition, because it's in no one's interest, sign an agreement, get started, and then 2 weeks down the road, when we're just collecting the initial documents, we find out, hey, this isn't going to work because the client doesn't have X, the client doesn't have Y. It's just in everybody's interest to get that clarified at the outset. So assuming we have that initial kind of kickoff call or onboarding call, everything looks good. Then, we first start with the source of funds preparation. And that's what we've been talking about the last few minutes, because that takes the most time. And then what clients don't always understand is sometimes clients think, I got to pick the project first. That's like the hard part, right? They think that's the hard part, picking the project. I'll work on the source of funds later. No, you don't want to do that. You want to start with the source of funds work first. And at least after you start working with your attorney, you have a good idea, okay, how much time is this going to take? Is it going to take a month, 2 months, maybe even longer? Because there's no value, or very limited value, of picking a project up front when you don't know how long it's going to take to do that source of funds work. Because these regional centers, they're not going to hold a spot for you indefinitely, right? And especially as we get closer and closer to October 1st of 2026, these projects are going to start filling up faster because there's going to be more investors. We know it, it's coming. And so there's no way, they're going to hold a spot for you and wait 90 days for you to finish the source of funds work and then make the investment. So what we usually advise clients is, start the source of funds work. Let's at least get halfway through or more to have an understanding, when can we finish the source of funds work? And then when we see the daylight at the end of the tunnel and we know, hey, this will be finished in 2 weeks or 4 weeks or whatever, then we might say, now's a good time maybe to start looking for a project.
I would say sometimes, Charles, and quite often I don't even have all the documents. For example, again, if we return to US and W-2s, I'm mostly looking at bank statements, because it's not so hard to get your tax returns for last 7 years. It's not so hard to get your W-2s, pay stubs. So when I know that we're going to get it and contracts and letter from employer, I work mostly just on a bank statement and as many bank statements as I need. Then I tell client, if you want to secure your place in this project, you can do that. Go ahead and invest partially or completely. And then we will collect remaining documents because we don't even need to translate them from English or to English. So yeah, there are situations when we can say it earlier than later, but please never invest before we say it.
Yeah, exactly. Yeah. So, yes. And so when we think we're pretty clear on the source of funds, even if we haven't gotten all the documents, like Yulia said, or even if we're still working on it, if you selected a project, and we're happy to provide, recommendations of centers we worked with in the past as well. But if you selected a project, you signed all the paperwork, and we give you the go-ahead, the green light to make the investment, even if we're still working on the documents, that's okay. As you know, you have to make the investment of the funds prior to filing the I-526 to get the conditional green card. Once you make that investment, then and then we file the petition, then it's a waiting game. How long you have to wait really depends on the type of project. If it's a rural project, those are getting reviewed within 12 months for the most part. Some are getting reviewed faster. Some are taking a little bit more than 12, but for the most part, it seems like USCIS has set a goal of 12 months for rural projects. If it's an urban project, it's anybody's guess. It's probably 2 years to 3. It could be all over the place. And here's the interesting thing too, Yulia, I don't know if you heard about it, but USCIS came out maybe with a policy update maybe a month ago, I think in February 2026, where they said that, consistent with congressional intent, whatever that means. I mean, basically consistent with the law, with the RIA, that, they're putting a priority on rural projects. So I'm not endorsing rural projects, saying everybody's got to run out and invest in a rural project, but be prepared that if you do invest in an urban project, CIS has basically let everybody know that they will work on those projects to the extent they have free time in between, working on the rural ones. So it seems pretty clear that for rural projects, that's where their efforts are being focused in reviewing them.
Basically, it's how we're supposed to be since 2022, because he says
right.
Yeah.
So maybe with that, there wasn't anything really new. They just kind of formally recognized it. So the other interesting thing about this policy update, which was more newsworthy, let's put it like that, was the fact that they made it clear that they basically will not start reviewing investor petitions until the project has been approved by USCIS. So if you're an investor looking at projects, the first question you want to ask, or have your attorney ask, is, has the project been approved by USCIS? Because in the past, it was sufficient just to, if the developer or the regional center said, yes, we submitted the 956, right? We submitted the documentation to get the project approved. And they could start recruiting investors at that point. But USCIS has now made it clear that they will not even start looking at investor petitions until that project approval has come forward or been made, right? So if you're looking at projects, I mean, it's pretty explicit. You're going to want to invest in projects that have already gotten the 956 approved, because otherwise, there's going to be delays. And otherwise, as you know, with that one client, Yulia, with the one project, they had significant delays just because USCIS was really reviewing the project. And I think it was like 9 months or something, right? 12 months that they were reviewing it. They ultimately approved it, but that really created some headaches for our client.
They also had request for evidence and NOID. Are you talking about this project? Yeah.
So a very important piece of information going forward is make sure that project has been approved, because otherwise you just might get caught in that, never land of waiting for stuff. So let's go on to the next topic. We talked about choosing projects, and clients often ask questions, well, how do I find a good project? And I'll admit, there's limited resources online where you can get objective data. I mean, there's forums and people talk, hey, I invested in this project and it was a dog, or I invested in this one, it was great. I think that's very unreliable. I don't know how much you can really rely on these forums and these, third-party estimates, because, people have different experiences, and some have great experiences, some don't have good experiences. And there's no public ranking system of these projects. And if you go to USCIS's website, there's no information there. All you can find out is whether the regional center exists. So I think a lot comes down to looking at the track record of the regional center, looking at the relationships, maybe getting recommendations from previous investors. And some regional centers do that. They'll say, hey, you can talk to these folks of ours. They went through the process, whatever. And I also think attorneys can be a valuable source too. I know a lot of attorneys don't like giving advice about regional centers. We're not one of those. We're happy to share our experiences with, regional centers that we've worked with, over the years and, with whom we've had good experiences. So I think that's an area where we can provide some, added value to our clients as well. Timing, we discussed the timing, that rural projects are getting approved in about 12 months. Urban are taking 2 to 3 years. Yulia, one question that people ask a lot of times is whether they should do consular processing or adjustment of status. How would you respond to that?
Absolutely, adjustment of status. After 2022, no doubt. Consular processing, it's first of all a chance to get your petition reviewed second time. Even though it was approved, they may be asking questions about your source of funds, looking at path of funds, looking at your history, and they have authority to deny and then send your petition back to USCIS for revocation. So USCIS, you went through that process once, that's it. Hopefully no one and never will go back to that.
Right. I think you're maybe jaded a little. So I agree with you. I think your assessment is particularly true for people from certain regions. So if we're talking about like from the republics of the former Soviet Union, Russia, Kazakhstan, those countries.
We had experience in France, Charles, which was very
true.
surprising with French client. And she was actually asked about the project itself. And usually because it's a regional center, people are less involved. They don't have so much information. And for some reason, officer wanted to know more about the project. The person was approved. Yeah. Everything was great at the end, but yes, they're asking questions.
That's true. And it also depends on the country so like you said, it's not limited to developing countries. Like we had that client in France. She had some really tough questions at the interview. And even like Canadian clients, right? I don't know what's going on at the U.S. consulate in Montreal, because Montreal, that's where they issue all the immigrant visas, but it is taking years. I mean, it's backlogged so much that's one reason we tell our Canadian clients, look, if you want to get this done in a timely manner, you might wait 1 or 2 years to get your approval from USCIS, but you might be waiting another 1 or 2 years or longer just to get your interview in Canada. So I think with our Canadian clients, we definitely, suggest adjustment of status here. Now, there's pros and cons of that, and we don't have time maybe today to go into that. But I agree, Yulia. Yes, if you do an adjustment of status in the U.S., you're minimizing, first of all, possible delays, and secondly, you're minimizing another set of eyes, somebody at the consulate looking at your case again, raising more questions. Because when they look at the case at the consulate, theoretically, even this is all one government. USCIS is a different agency from State Department. And the State Department, they have their own criteria that differs a little bit from USCIS's. And they might say, hey, let's see your source of funds again. They might reopen and look at that. Or they might have some other criteria if you had some immigration problems in the past or something. They leave it to themselves to have the right to review anything when you're at the embassy. So that can get a little nerve-wracking, I guess, at a minimum. And sometimes it can create, problems. If you get a bad officer that doesn't have experience. With the remaining time, I just wanted to go through a couple other quick issues in terms of, we talked about this in terms of the investment cycle, how quickly investors can get their money back. The law says you cannot give a date specific when you're going to return that money. You can't promise exactly in 3 years from your investment date, we'll give it back to you. You can say starting from 3 years, we'll return it, or starting from 3 years, provided that we meet these criteria or requirements, interest rates are at this level or stuff like that, they can return the funds. So that always creates some anxiety maybe with our clients, because you never know exactly when the funds are going to get back. And this is another reason why selecting a regional center with a good track record is important, because you can look at, how many cases they've had, 10, 20, 30, 50, and what has been the pattern for paying back the funds. Usually I would say the shortest return time we see is maybe 3.5 years. Average is maybe 4 to 5 years, but it could easily go to 6 years or longer because most of these agreements are written in a way that, there might be an initial period of say 4 years, but they might have a renewal option, or an extension option. And that might be for 1 year or could even be an extension for 2 years. So when you're going into this, you need to be cognizant of the fact that there could be delays, there could be extensions in returning the money. And that's just something you need to work with your attorney to look at, okay, what are the conditions for the extensions? What happens? A lot of times when there's extensions, they pay a higher interest rate to the investors or maybe make some other actions that would motivate and incentivize the developer to settle up with the investors sooner rather than later.
Anyway, Charles, it should be shorter period of time that it used to be before 2022.
Yeah, absolutely. Yeah. Because there were a lot of delays.
changed.
I don't know. Do we still have any clients from 2019 who are still waiting for approval?
Yes.
Yeah.
Yes.
So that's poor folks.
A few with RFEs that we answered almost 2 years ago.
Yeah. So here's a couple, Yulia, I'll ask you, we'll do a kind of like a blitz survey here. I'll ask you a couple questions about life circumstances that might affect people's petition. And this might affect who would be the investor in a particular case and stuff like that. So here's and these are real life samples. We've had cases of all these things come up in the past. So what would happen if the main investor were to pass away? How would that affect an EB-5 petition?
If you received green card, then you're in a good place. However, if the petition is still pending, or even if your green card is pending, this is very problematic. There is no clear rule, and the one that exists says that the person who can take your place, investor's place, like relative, wife or a child, have to be present here when the petition is approved, and some other, I can't even recall rules, so it's pretty complicated.
Yep.
We would not recommend it. So
I don't think anybody would recommend the passing away of an applicant, but
think about your health.
Yeah, that's right. Eat well, get lots of rest, don't smoke, don't drink too much, take care of yourself. Yes, that's the best advice we'd have. So as you said, right, once you get the green card, at least the conditional green card, the family members are pretty good to go. And if you can imagine this, we had a case where the clients went to the interview at the embassy. They didn't get the visas issued. And then tragically, the main applicant, the husband, passed away in an accident shortly after that. And we filed an appeal and we were rebuffed several times and we appealed it. And it ultimately was approved. It took years. And by that time, the widow, she had actually gotten remarried and got her green card through marriage. But we did prevail on that. So yes, it can be a problem with the death. How about in the scenario of a divorce? How does a divorce affect an EB-5 petition?
Basically, divorce is a little death. It works the same way. If you divorced before EB-5 approval and before getting green card, then only investor and children can get green cards. The divorced spouse cannot. If you got green card, then even if you divorce, you can go and get your permanent after conditional one.
Yeah, exactly. Yeah, that's a good analogy. It's kind of like a little death. I never thought of that, but I guess that's a good way of looking at it. One thing that people also bring up is the travel rules. Like, how much can I travel? How much can I be outside the U.S.? So the general rule is, if you're out of the U.S. on any one trip, less than 6 months shouldn't be a problem. This is after you've gotten the green card, right? That's fine. If you're gone from between 6 and 12 months, then you need a good explanation. You need a very, worthy explanation, reason why you were gone more than 6, but less than 12. Maybe you had a medical operation, and we've had clients like that, or a close family member overseas that required, constant personal attention. And as long as you can collect enough paperwork to document this, it shouldn't be a problem. But the bigger problem, I guess, that comes up if you're absent for 12 or more months, right?
Yes, because then you most likely lose in residency, very high chance. But I would also say, Charles, if you absent less than 6 months, but close to 6 months, what people do, if you do it once, it's okay, but you can still go to secondary inspection at the customs. You can be asked questions why and whether you intend to remain lawful permanent resident. But if you absent for up to 6 months every time you live in the country and spending here less time, it raises doubt that you want to be permanent resident, and they can also initiate the proceeding.
Yeah, right. And given this current administration, they're more likely to do that than, say, in the past. I mean, fortunately, we've never had a client who ever got, turned away at customs, when entering the country. And we've had some clients, I mean, this situation was unusual, and I'm not encouraging people to do it, but we even had a situation where the parents, the family had been out of the U.S. for a long period of time. I can't remember how long. And the problem was the parents had gotten passports for themselves. And I think and the other children were American born, but they forgot about the oldest child who only had a green card, and they were out of the country for, gosh, I don't know, 7 years, 5, 6. I mean, it was a long time. I mean, his green card had long ago expired. And, they let him in at the border. We came in, we prepared kind of a letter, a good explanation, what happened and whatnot. Now, this was before the second Trump administration. I think it was during Biden. So they maybe were a little bit more flexible. So it is possible to get in. If you've been gone for, more than 6 months or 12 months in particular, it's possible it can be very difficult. And as Yulia mentioned, even if you're not exceeding that 6-month threshold, they very likely could ask questions, especially if you're repeatedly gone for long periods of time.
Also, what is important, Charles, I think to remember for clients for the future, even if you're absent here, like twice a year, you go less than 6 months and less than 6 months, and in total you get over 6 months. For tax purposes, other rules applies to you than the one when you were coming here as a tourist. If you're outside of here for over 180 days, so inside here you less than 180 days, you are still a tax resident. Mm-hmm. Which would be different with a tourist visa.
Right. So yeah, to generalize, you could be gone on a green card for, even 10, 11 months. We're not suggesting that, but you still got to pay taxes as if you were here the whole time. So I suppose if you're going to have to pay U.S. taxes, I guess maybe enjoy your time here and spend your time, I guess, because yes, once you have that green card, folks, you're a U.S. tax resident regardless of how much time, you spend here.
And also, I know that sometimes accountants say that you don't have to file tax returns if there is no income. For green card holders, I would still recommend filing tax returns.
Yeah, absolutely. Right. Because if you're ever going to go for citizenship, they're going to want to see those tax returns. And if there's a gap, it's more difficult to explain why there's a gap as opposed to, here's my tax return. I filed it. I had very little income that year. Maybe I didn't even have to pay taxes, but at least you filed it. So yeah, that's also very important. Here's something I just wanted to talk about. What are the risks involved with EB-5? Maybe from the project side of things, right? And or maybe not just project side, but in general. And we can run through that really quickly. I mean, so there's project side and immigration related risk factors. On the immigration side, okay, what's the risk? Well, the biggest risk, I guess, is you would get a denial at the first phase of the process at the 526 phase when you're trying to get a conditional green card. Actually, I think about that, Yulia. So as everybody knows, just so we're on the same page, there's 2 phases, conditional green card and then a permanent green card. I don't think we've ever had a denial for a permanent green card, right? As far as I can recall, Yulia. So that 829, that second phase, it's usually pretty easy.
We had requests because usually they ask about projects, and with regional centers, they usually providing all the necessary documents, even if there is a request. Most problems we had when we were receiving requests, it's when client was here, got few DUIs or something like that. Yeah, if there is a record, this is the most common situation regarding that concerns client, not the project during this stage.
Mm-hmm. Right. So yeah, we're assuming you're law abiding and haven't had any run-ins with the law. But yes, 829 process is, as long as you're working with a reputable regional center and everything is more or less okay with the project, the 829 is a bit of a formality. I mean, it's very rare to have problems unless, you have a criminal record or there's some other issues. The biggest challenges and the biggest immigration risks are at the first stage when you file the 526 for the conditional green card. And under the current law, where all the projects have to be pre-approved, it's extremely unlikely at the 526 phase, you're going to have questions about the project because USCIS has looked at the project, they reviewed it, they've approved it. There shouldn't be any questions about it. So if there is a challenge or a problem at the 526 phase, it's almost invariably due to the source of funds. And so That's why, source of funds is so critical. It's make or break for the most part, because you've got an approved project. The only reason you could get a denial is because of the circumstances of the individual investor. So that's where the biggest risk is on the immigration side. On the project side, on the business side of things, right? And here's a question that we can discuss is, well, let's say there's a problem with the project. They don't finish building the project, or they finish it, but it's losing money, or they finish it, it's losing money, and then it goes bankrupt. Those three scenarios are theoretically possible. They're very unusual, but they could happen. So maybe we should discuss how that would affect the immigration process. So I'll take maybe the first scenario. You can do the next step. So let's say the project is never finished, right? They just never even build it. Theoretically, depending at what point they kind of give up on the project. Again, I can't really think of a case we've ever had this in 20 years where they didn't finish the project. It's almost unheard of. But let's say for whatever reason, they didn't finish it. Can you still get your green card? And the question is, how much money was invested, was spent, and how many jobs were created before that moment in time? And so if they created enough jobs for those investors that invested the money, 10 jobs per investor, you could still get your initial green card. You might not get the 829 approved, right? It kind of depends again on that job creation, but you might not get your money back, right? That's the risk there. Now, I think it's very unlikely that a project will not get completed. That's extremely unlikely, but it could be completed. But here's a scenario that might come up. Let's say, Yulia, they complete the project, it's operating, but for whatever reason, instead of building, again, I'm making up these hypotheticals that are so unlikely. Instead of building 50 stories for the hotel, they only built 20 because they ran out of money. Or let's put it like this. Let's say they're operating, they completed it as planned, but, the hotel sector is down, the market's down, they're not getting the occupancy they anticipated, and so they didn't create as many jobs as they thought. Will the client still get an approval for his or her?
It depends how many clients. So probably not every investor will get an approval because we need 10 direct or indirect workplaces for each client. So whoever comes first, whoever is
First in line, yeah.
Approved, yeah. Then they get places. Okay. The rest,
And here's the thing to do it and as you said, it really depends at what point in time this happens. So you don't have to create, to get the 526 approved, we don't have to show that the jobs were created by that time, right? We just have to show when we go to get the permanent green card.
829.
Yeah, the 829 that they were created. So here's a scenario too. Again, this isn't, I've heard of situations where these were smaller projects, maybe not regional center projects. They got 3 or 4 investors. They opened a restaurant. The restaurant wasn't doing too well. They didn't hire so many people. It's okay. You still could maybe turn things around as long as you get those jobs created by the time the clients go and do the 829. So, that is all, doable. It just depends. So I guess.
But I believe the difference here, even if you can keep money shorter period of time, but you have to create workplaces at the time when your money is there.
Right.
So if you create workplaces later, it means you have to keep your money over there for longer period of time. Right.
But if they could show that the jobs were created while the money was invested, and then they take it out, then theoretically at the 829 stage, they should be okay, right? I guess what I'm saying is the issue of reviewing and analyzing the job creation, that occurs at the 829 stage. The jobs might have been and should have been created before then, but the government doesn't really count them until you go to the 829 level of doing stuff. Why don't we talk in the remaining time here, just briefly about the gold card, because that's a hot topic lately. And a lot of people who are considering EB-5, they're also looking at the gold card. And as you know, this was announced in the spring of 2025. By the time of this podcast recording, which is spring of 2026, it still hasn't been launched. And in fact, there's been a lawsuit that was filed in federal district court, I think in DC, challenging the whole premise of the gold card and whether it's legal and stuff like that. So it's kind of funny. They haven't even launched the project, but it's already been challenged in federal court. But for those who aren't aware, the gold card is basically a donation to the U.S. government. You donate $1 million. It goes to the federal treasury. You don't get any kind of income. You don't get a return, and you don't get that money back. And despite those terms, Yulia, as we know, we've had quite a few people who are interested in the gold card, as it was at least described to all.
And you invest for each family member.
Yeah, so you have to invest $1 million per person. So if you're a bachelor with no family, okay, maybe it's not a big difference. Now, I think the big appeal that everybody was all excited about with the gold card was that supposedly you don't have to prove the source of funds to the same extent that you have to with the EB-5. Whether that's true or not, nobody knows because the process really hasn't been launched. What I've heard from the industry, and I think you've probably heard the same things, Yulia, talking to other lawyers and stuff, I think legally it's almost impossible for them to do that, right? I mean, they can't say not that they're ever going to say this, but they can't say, hey, we'll take your dirty money. If you have dirty money, use the gold card, don't do the EB-5. But I think, different government regulations would still require them to verify the source of funds. So I don't know how much easier it will be.
I think it may be easier. I think it may be more similar to E2 visa, Charles, where you show, I had the company, I received dividends. This is the activity my company was involved into. And you don't have to show how you started the company, how many years ago, how you invested money, or if you took a loan, how you repaid the loan and then kept working. None of it. The same with the property. You show when you sold the property, they're not asking. Only once in few hundred petitions, I think, Charles, they asked us for E2, how did you buy the property? So I think for gold card, it may be something like that, just to show that the last source that you invest in, it was lawful.
Right. And there's kind of been movement towards that with EB-5 too, right? There's been some judicial precedents that seems like the courts are kind of trying to push USCIS in that direction, right? For EB-5, that you don't have to show that if you can show the most recent source, and I forgot the name of that court case. I mean, they have
the last from not 25 from 2024. That was a complicated name. I don't remember it either. But I feel, Charles, that USCIS really doesn't care, considering the request they're sending us. They started challenging pass of funds more from previous funds, like someone gifted, then they received, they sold property, they received salaries, they go in backwards and backwards. So USCIS really doesn't follow it. So we may have to challenge it again.
Well, this old administration, they seem to be ignoring a lot of courts and what the courts are saying, not only in this context of EB-5, but other areas as well, as we know.
Honestly, my own feeling is that all those challenges to EB-5 are coming to encourage people to go for gold card. Even those 75 countries that cannot go receive immigrant visa right now, I have a feeling it's also because they want to push ahead gold card. But it's just my theory.
Yeah, could be. So in conclusion, maybe we should we've been talking here for about an hour. We can try to pull together everything to summarize it. What we've kind of been talking about. So if you're looking at EB-5, as Yulia and I have discussed, key deadline coming up September 30th of this year. If you miss that deadline, it's not the end of the world. The program as it exists will still exist at least until the end of September 2027. But if there's any changes, you would be affected by them. What would we recommend?
Charles, I would say, if I can interrupt, I would say changes if they do not extend the program right away. You will be affected for sure.
Correct.
They will not be reviewing.
Right.
But if there are other changes to investment or something else, you should not be affected retroactively. At least we don't know about that.
Right. Not retroactively, right. But nonetheless, yeah. I mean, how the whole grandfathering was written, why they did the grandfathering a year before the regional center statute expires, I don't know. But, it is what it is. I think there's a lot of thoughts that they were in such a rush to prepare everything, they maybe screwed up the dates on that. But anyway, yes, I mean, if you're looking at filing, the safest route is try to get something filed before October 1st. Try to choose simplicity over, optimization, meaning, when working with an attorney, as we said, try not to get too many sources of funds involved. Try to, make the story, the narrative for the officer is simple and understandable as possible. And here's a question too. We didn't bring this up. How do you pick a lawyer that, an attorney that knows what they're doing? And without, any self-promotion here. I mean, what we tell our clients is, first of all, if you're comparing between different lawyers, what I would do is, first of all, certainly the length of experience they have. That's important. And if somebody says, oh, I've been doing EB-5 for 5 years, 5 years sounds like, okay, not too bad. But I have to tell you, in the EB-5 world, that's nothing, especially because, as you know, Yulia, we just talked about this, right? We still have cases from 2019, 2020 that are still being reviewed. So let's say an attorney started their EB-5 practice in 2020. It's quite possible they've had no approval since then, or very few. So they have no feedback from the government as to whether what they were doing 5, 6 years ago was even proper or correct, how they were preparing, the petitions. So I would say for any attorney to work with them in the EB-5 space, they have to have, I'd say, at least 7 years of experience, ideally more, so that they had adequate, feedback from the government to see, okay, are they preparing these petitions correctly? So what we can say on our behalf, we've been doing this about 15 years. And so that, and I think, Yulia, you can attest to this. We've had a wide range of experiences, and especially maybe our work with a lot of Russian investors or investors from that part of the world has certainly given us maybe a jaded view of EB-5, but certainly given us good experience, because if there's any nationalities that probably get scrutinized very closely, it's people from that part of the world. And I'm sure, had some very tough cases from those clients, or with those clients.
Also, I would say that if someone tells you that it's easy, you just need to invest and we need like few registry, it's not.
Yes.
I'm not a pessimist. I'm an optimist in life, really. But with EB-5s, it's not easy.
Yeah, absolutely. That's a good point too. If any attorney you're speaking to says, hey, it's easy, we can do a great case for you, it's not going to be a problem, you probably want to talk to somebody else, because they're not being honest with you at all. Even in easy cases, quote unquote easy cases, there can be a lot of complications that can arise. So you really want to get somebody who has years of experience. Like I said, we offer this to clients too. We might say, we can try to make arrangements so you can speak with some of our former clients and they can talk about the experience they had with working with us. I think a lot of law firms won't even go to that extent. Sure, it's a bit of an inconvenience to some of our clients, but look, hey, if we're providing such a valuable service to our clients, helping them and their family acquire residency here, vast majority are willing to, share that experience with new clients and share that with them. And so that's something we also do to give clients, a level of comfort when they can speak to other people, especially if they're investors from their home country, where they can kind of, get firsthand feedback as to what it was like working with us. And I think the other thing, Yulia, that sets us apart also is we're a relatively small firm. And so there's a lot of attention given to each client. There's not multiple levels of assistance and paralegals and legal assistants. Some of these larger law firms, they've been around even longer than us, but the amount of attorney time you're going to get with them is extremely minimal.
I agree.
Yeah. So you'll become very close friends with us, and especially Yulia working on, an EB-5 petition. And I'm sure you're not always going to get that same level of attention with other firms. So anyway, to wrap up today's session, again, EB-5 may not be for everybody, but if it does feel like this might be an option for you, you should probably make a decision sooner rather than later, given this upcoming, deadline. This is a strategic decision for you and your family. And so you need to make sure that this is the right decision for you guys as a family, and then come to us where we can talk about the legal side of things, the business side, to make sure, yes, we can put together, a petition with minimal risk to ensure, approval. So
please don't wait until you put all the money aside. We even have clients that we started working with, but we're not getting documents because he wants to make sure he has all the funds. He knows he will have all the funds soon. And I'm asking, don't do that, because I have to review it first. Give me time, because right now with a deadline, we have a line already. So sometimes I may have a break and take new client who just came. Sometimes I have to work on already several cases to file this month. I'm filing this month and cannot work on newer cases. So,
right. So yeah, timing is very critical. And like you said, don't try to do too much on your own before you're working with an attorney, because what you think is maybe good for your case might actually create an extra level of complication. So best to get advice from an attorney first, and then, develop the strategy and go from there. So for anybody who thinks this might be a valuable avenue or option for them, I would suggest reaching out to us, book a consultation. We can do an eligibility assessment about your source of funds and all that. And if at that initial stage, we feel, yes, we can go ahead, again, before we get any documents, because once we get the documents, questions always come up that we don't anticipate. But at least at the initial stage, we'll do an eligibility assessment. If we think it looks like it's going to work out well, we'll start the process, get that going. And as we discussed, then we do the subsequent steps, looking for projects, securing a place in a project for you, and then hopefully getting you filed promptly and hopefully before October 1st. So hopefully this was of benefit to you all. I think this is a great opportunity. At least, EB-5 really helps a lot of families, and we'd love to share that opportunity with you and your family as well. Thank you, Yulia, for your time and your input.
Thank you, Charles, for having me.
Yes. Until next time, thank you, everybody, for your time.
Thank you.